Hello, I would like to share some information with you about TextLimit.com. Our smartphone app is an effective tool to help limit liability for business owners and companies due to distracted driving. Your employees are your most valuable assets, but keeping them safe on the road has become a challenge with today's technology. The temptation to be more productive while driving by sending and checking texts or emails has led to numerous accidents. Distracted driving has become an epidemic in the U.S. Unfortunately, these accidents have created a new risk for business owners and companies. When your employee has an accident, you could be liable. Here are a few examples of recent lawsuits. Roberts versus Smith Barney, United States District Court, Pennsylvania. A $500,000 settlement was awarded. A stockbroker employed by Salomon Smith Barney was driving to a non-business event when he struck and killed a 24-year-old motorcyclist. At the time of the accident, the stockbroker was on personal time, in a personal vehicle, and using a personal cell phone. He admitted that he had been making cold calls, a common practice among Salomon Smith Barney's stockbrokers in an effort to contact some of his clients. Although Salomon Smith Barney believed it could prove the employee was outside the scope of employment, the company recognized that in permitting and expecting its employees to make cold calls while driving, the company policy itself could be deemed negligent. A $21 million verdict. This award arose from an accident in Florida in which an elderly woman was seriously injured after being struck by a truck that was driven by an employee of lumber giant Dyke Industries. Although the employee initially denied being distracted at the time of the accident, his cell phone records proved that he had been using his phone at the time the crash occurred. Because the employee was in a company truck and on duty at the time of the accident, Dyke Industries was held liable under a theory of vicarious responsibility. The case was subsequently settled for $16.2 million. A jury in Corpus Christi, Texas, awarded $21 million in damages to a woman who was struck by a CocaCola driver who had been talking on their cell phone at the time of the accident. The plaintiff's attorneys were able to successfully argue that Coca-Cola's cell phone policy for its drivers was vague and ambiguous. They also suggested that Coca-Cola was aware of the dangers, but withheld this information from its employee driver, which led directly to the circumstances that caused the accident. As you can see from these few examples, corporate liability is a serious issue. Giving your employees the right tool to stop distracted driving may prevent these senseless accidents and mitigate your risk. The TextLimit app is a smart solution to help your employees stop this dangerous and in many states illegal behavior. The TextLimit app is simple to use and very affordable. TextLimit is truly an ounce of prevention versus a pound of cure. Check with your legal professional and your insurance representative to see how the TextLimit app can be part of your risk mitigation strategy. Having a company-wide policy on cell phone usage, providing a tool like the TextLimit app, and training your employees to use the app are all part of a good strategy. Download TextLimit today to give your employees the tool they need to be safer on the road.